SJC-11943, Bank of America, N.A. v. Deborah A. Casey, trustee.
Good morning, Mr. Ponte.
Good morning. May it please the court. My name is Adam Ponte. I represent the appellant, Deborah A. Casey, Chapter 7 trustee of Alvaro M. Pereira, and we are before you today, Your Honors, on two certified questions of law from the United States Court of Appeals for the First Circuit. In 2005, the debtor in this case executed a mortgage in favor of Bank of America with respect to certain real property in New Bedford. The attorney who had witnessed and notarized that mortgage and prepared the certificate of acknowledgement, Attorney Quinton, he thereafter recorded the mortgage and the certificate of acknowledgement, and unbeknownst to the parties at that time, there was a material defect in that acknowledgement. And what was that material defect? The acknowledgement omitted the names of the actual mortgagors as being the persons who, of their free act and deed, voluntarily signed the mortgage.
So somebody looking at these documents wouldn't know that? Someone looking at the mortgage wouldn't know that, who it is?
No, Your Honor. The mortgagors are identified on the mortgage documents,
Right.
and in this case, the mortgagors executed each page, and their name is on the actual signature page, but the certificate of acknowledgement, where there's the actual statement, A and B signed this document in my presence of their free act and deed. Okay. That's where it's blank. And
What do
that's
the initials mean? What do the initials mean?
Different page.
Do the initials on the acknowledgement have any significance in your view?
I believe I misspoke. Are you talking about the initials throughout the mortgage document?
No, the initials on the acknowledgement itself. They did initial.
They did.
They just neglected to sign. So are we to take anything from the presence of the initials?
Well, my position on that is it's the notary's obligation to fill in the blanks in that acknowledgement.
Okay.
And it's not the mortgagor's obligation.
But the issue is whether or not the mortgagors are doing this as an act of free will. And if they acknowledge it, you understand the process that the person explains what is going on as you go through each page, and each page is initialed. And if the initial is there, doesn't that reflect some agreement with the questions that are being asked about whether or not this is your free act and deed?
I think that serves as evidence that the mortgagors were aware of what they were signing, and there are no facts in this case. There's no dispute here that the mortgagors did execute this mortgage, that they were there, and that the notary, Attorney Quinton, he was the individual who witnessed it.
What if the shoe were on the other foot here? And instead of the mortgage, it was the deed, and the grantor on the deed the grantors have their signature notarized, and your client is the trustee for the grantee. If the grantor's signature or grantor's names had not been in the acknowledgement on the deed, wouldn't you welcome an affidavit from an attorney saying, "Oh, I acknowledged the grantor's signature. This is who the grantor should be." Otherwise, it would delay the bankruptcy proceeding.
So I think to answer your question, we have to look at the old original formalities, the strict requirements that this court has required back in the 1930s in the McQuat decision, that we are to abide by and adhere to the stringent requirements specifically for certificates of acknowledgement. So in your scenario, I think the argument from my behalf is the same, because in that case, the McQuat case, the grantor was on his deathbed, and there was evidence that he knew what he was signing, that he intended to transfer the property to his wife, and it was notarized and witnessed. And regardless of those facts, and it was recorded, and regardless of those facts, this court in the 1930s concluded that that deed was ineffective. Why? Because there was no evidence of that affirmative statement that this was signed voluntarily and of my free active deed.
Yeah, but was there an attorney's affidavit in that case?
There was not, Your Honor.
Okay, so wouldn't you, that's why I say, wouldn't you welcome an attorney's affidavit to help the chain of title, clarify the chain of title, if the shoe were on the other foot in this case?
Well, with knowledge of the statutes that are applicable, I would look to Chapter 184, Section 24, which specifically provides the process by which, if you're within that 10-year statute of repose period, you can bring a proceeding on account of the defect. So knowing that under 5B, an attorney's affidavit, the language of 5B doesn't actually provide what filing this affidavit can do for you. All it states is somebody with personal knowledge of the facts in that affidavit who's making statements that could provide benefit and assistance to clarify chain of title, they can record that affidavit in the applicable registry of deeds.
Is there anything in the history of the passage of these various statutes that makes any connection between 5B and 24? In other words, were they amended somewhere at the same time or anything like that?
The information is relatively thin. The one piece I know is that in connection with memorandum of Liz Pendon's actions, 5B was modified in 2002.
In connection with 15?
Correct.
Yeah.
But frankly, I don't consider that to be a major issue in this case. Looking at the actual language of 5B, I think that's where we can rest our decision.
Well, you can, and how is that?
So as I apologize if I was not clear, under 5B, it simply states that an affidavit can be recorded at the applicable registry of deeds. It doesn't say what this can or cannot do. It does not provide that there's any...
Will be of benefit and assistance in clarifying the chain of title,
Correct.
right?
And when you look at 24, it actually identifies defective certificates of acknowledgement.
I guess my point is, are these mutually exclusive? I know you think they are, but are they? In other words, can't they be independent ways to remedy a problem such as this?
I think that a 5B affidavit can serve as evidence to remedy the problem, but I think that under 24, the legislature knew to create a statute to explicitly identify defective certificates of acknowledgement and other defects on instruments that convey title. So if your question is what can the 5B affidavit do, is that something that can independently resolve the issue? There are...
Well, in this case, because the issue can be resolved by an attorney on his personal knowledge. I mean, that's not true of every defect, obviously.
And our position in this case is that where this court has held that we must obey with the strict formalities of the certificate of acknowledgement, and of course, in that case, there wasn't a 5B affidavit, we probably wouldn't be here. Our position is that this unilateral act of a 5B affidavit can't be used as a replacement for this strict formality that we must follow. And if you look at what Chapter 183, Section 29 provides, that no deed shall be recorded unless there's an acknowledgement. The following Section 30, it provides the outline and the framework for what the acknowledgement must provide. And what does that say? That there's got to be a grantor or a mortgagor, and it must be executed before a justice of the peace or a notary in the Commonwealth.
Will you assume that the statute that refers to the deed is applicable here? Where do you get that from? I don't understand that. I'm asking.
Which statute, Your Honor?
I think it's Section 29, is it, that says you can't record a deed without the acknowledgement. So where does it say that that applies as well to the mortgage?
Yes. So General Law, Chapter 183, Section 29 states that no deed shall be recorded unless a certificate of acknowledgement is annexed thereto. My position is that this applies to this case because Massachusetts law has been consistent that a mortgage is a deed. We're a title theory state, and that really when somebody buys a home and they take out a loan and they give a mortgage to the bank, there's two things happening. You have equitable title going to the homeowner, you have legal title going to the bank. So the opinions of this court for a long period of time have held that a mortgage is in fact a deed. And when you look at the full construction of Chapter 183, there are different types of deeds identified within the chapter. And my position is that under 29, rather than listing out warranty deed, quitclaim deed, mortgage deed. They just said deeds. And they did that because it's clear in the law that a deed is a mortgage.
Now, let's assume you win,
Yes.
okay? Going forward, a notary as here makes an error, files it without having written the names of the parties in that certificate of acknowledgement. You say you can repair it under Section 24. How does that work?
Okay. So there are, in my opinion, two methods through 24 that a notary such as Attorney Quinton could resolve this issue. The first is that he could bring a proceeding under Section 24.
What does that mean, a proceeding?
It could be
You
an
mean a
action to
case?
action to quiet title.
And what's his stand, as lawyer for somebody, what's his standing? He's the plaintiff?
So I apologize. It would be Bank of America as the legal title holder on that property.
So
They
B-
would have standing.
So B of E would have to file a complaint seeking to quiet title?
That's one option. The other option is that in this case where 6.5 years go by and they realize that, oh my gosh, the acknowledgement is blank, they could seek assent for a re-acknowledgement to a mortgage. They could prepare a new document and have it re-acknowledged and have the actual assent of
And
the
why
mortgagor.
why would the mortgagor, in his or her right mind, ever do that?
Exactly, and that's an excellent question. And so, taking your question into account, I would then say that if the bank is compelled to bring a proceeding to remedy the problem, then if they did file a 5B affidavit, which I'm not saying they can't, because there are opinions that my brother counsel here has cited where 5B affidavits have been used, it would serve as evidence. So let's say there is no evidence here that there was fraud and that the debtor did not sign the mortgage. Well, then you would have evidence here, 5B affidavit. There's no one disputing that fact, but that's the procedure that needs to be followed.
So why are you downgrading a 5B affidavit to mere evidence? If it's a 5B affidavit, it's there to accomplish the purpose of the statute. It's not just mere evidence.
I believe it's because it's a unilateral act. It's one party doing what this court and the statutes require two parties to do initially in that original recorded document. And where this subsequent recording is done.
Well, they did do it. I mean, the mortgagors signed the mortgage. They initialed all the pages, and nothing is being added here that didn't happen already.
And my point is that in terms of the process that must be followed, a 5B affidavit can't be the end-all, be-all. It can't be the one thing that corrects a material defect.
Well, what's the point of a 5B affidavit if it's not to, I forget what the language is, inform something about the chain of title?
To provide assistance and benefit.
Yeah,
to clarify chain of
yeah,
title.
that's a very broad construct.
And there are a number of cases that we have before us. We have the Cubelis case, where a 5B affidavit could have been used to correct a misspelling on the name of a homeowner on an execution. We have the Baker case, where really the court used the 5B affidavit only as evidence at trial and only allowed it in as a declarant of a deceased party under the hearsay exception. We have the Gonick case, where a 5B affidavit was used to correct an incorrect date on a notice of foreclosure, and that court actually specifically said, this is a scrivener's error, and we're going to allow the use of a 5B affidavit, but we are in no way making a determination whether a 5B affidavit can correct a defective deed.
Well,
That's,
is your brother saying that it corrects it, or does he say it just puts you on notice that, as to the true facts of the case?
I believe Bank of America's position is that it serves to correct.
Would they have alternate positions, right?
Yes. And the other position is, if we were to step away from question number one, question number two is whether the 5B affidavit provides constructive notice to the trustee. And I'm happy to address that if that's okay with.
It's okay with us.
Okay. So under the second question, under 11 U.S.C. 544, the trustee has the power to avoid a transfer as if she were a bona fide purchaser. And what that means is the trustee is held to a constructive notice or a legal notice standard, not actual notice. And what Bank of America argues is that, well, the trustee should be on notice because if a title examination was done, she would have found the mortgage. But really, a title examination doesn't provide legal notice. All it does is provide actual notice to the trustee, and that is not what is to be imputed on the trustee. In the case that they cite, the Adams case, where a title examination revealed a mortgage, the question in that case, there was no issue with the underlying mortgage being materially defective. The underlying mortgage was appropriately recorded. The issue was that the plan description for the plan of land did not match up with the plan description in the mortgage. And the court said, well, the deed description for the land and the description of the land in the mortgage, they matched up, and that's good enough. Constructive notice on the
Let me ask
trustee.
you this, are you
Yes.
saying because this, and I take it that some of the bankruptcy, I think, some of the bankruptcy judges have said this, well, if not having the acknowledgement filled out properly is a, what's the word, kind of error?
Material defect.
Material defect, thank you. Does that mean that the foreclosure is no good because of that?
Yes. So the Giroux, the Bauer, and the Nistat opinions all have similar defects to what we have now. And the big difference is that there's no 5B affidavit.
So these, the Pereiras
Yes,
could go into court and get their house back? Because, is that right?
technically.
So it's your position, I take it, that if the attorney affidavit statute only puts the trustee on notice, it doesn't make any difference because the trustee has the power to set it aside.
Correct, because how could a subsequently recorded document, especially a subsequently recorded document done unilaterally, give constructive notice of a document that can't give notice of itself?
So the only thing that would save the Bank of America is if we were to say that the attorney affidavit has the effect of correcting
That's my position.
as a matter of law.
I agree with you, Your Honor. Yes,
All right, thank you.
thank you.
Good morning. If it may please the court, Mark Johnston representing Bank of America, along with attorney Kathleen Heyer. Welcome to the real world of real estate.
We've been there before.
We've been here
I
before,
know
I
you
think I
have.
want to leave it.
I want to rent.
Yeah.
This case involves the interplay, really, of two statutes. We're dealing with 184, we're dealing with 183, Section 29, which I look at as a statute of repose. It's been referred to in other cases as almost like a safe harbor. A instrument which may otherwise be defective after 10 years is no longer defective.
Is that section 29, did you say, or
Section
section
24, you mean.
I'm sorry, it's, Section 24. 184, Section 24.
24,
Yeah.
okay.
The interesting part of this case actually is it's gone on so long
You
that
may get there.
that I believe 45 days ago, the 10-year period expired.
Does that make it moot?
It may very well. We've not briefed that issue, but 45 days ago, right after Christmas, the 10-year period was up.
Could you address the last point that your brother made, that, look, if all we say is that the attorney affidavit statute puts them on notice, that it doesn't solve your problem because the trustee has the authority to make this, to set aside the transaction?
The trustees' authority comes under what they call their strong arm provision of the bankruptcy code. And it would allow a trustee to avoid a transfer of an unperfected security interest. The difference is it makes a distinction between actual notice, being someone told the trustee something, as opposed to constructive notice, which is what's recorded at the Registry of Deeds. And the cases the cases are out there. The Swan case recently was out of the appeals court, went back to Land Court, but it talks about constructive notice is found by reviewing the records at the Registry of Deeds. You're put on notice whether or not you actually come across a document that you end up having notice of it, you take subject to it. Now,
Are you confident that you can prevail in the federal court if all we say is that the attorney's affidavit statute puts him on notice?
I think it's both. It puts them on notice as well as constructive notice, because I think it's the review of the records at the Registry of Deeds that you come across a mortgage initialed by, every page initialed. You have a certification by a notary. It's missing the names, but it does the mortgage itself. When you read it,
But the bankruptcy cases say that's a material defect, correct?
The bankruptcy cases say it, but we're here because it's an unsettled question. And the U.S. Court of Appeals, during oral arguments, decided that the case was appropriate to be certified to this court.
But that's not,
This is, I guess, where we're confused, because if the person reviewing title looks and sees a 5B affidavit and looks at it and says, well, they're trying to correct it, but they can't, doesn't have any legal consequence, why does that give them constructive notice of anything that matters?
Well, I believe, first of all, that the 5B affidavit corrects it.
Well, I understand that, but
and-
the question Justice Spina had was, if it did not correct it, can you prevail? And you said yes.
And I think because the 5B affidavit alone provides constructive notice of the existence of the mortgage.
So if that's all we say, you're going to jump for joy.
If you say that the 5B affidavit provides constructive notice of the trustee, then I think that answers one of the questions
Constructive
that's been
notice of the,
certified to
of
this court.
what?
of what?
Of constructive notice
Of
of
the
what?
mortgage,
Of the mortgage.
of the mortgage.
But if it provides constructive notice of a defective mortgage, so what?
Well, no, I don't think it provides constructive notice of a defective mortgage. Our position is twofold. One, the 5B affidavit, taken in conjunction with the recorded mortgage, makes that mortgage a good mortgage.
Okay, if you're wrong about that, if you're wrong about whether or not it corrects the defect, then what?
If I'm wrong about whether or not it corrects the defect, then the next question is whether or not the 5B affidavit on its own, stating the names of the mortgagor, the mortgagee, the principal amount of the loan, the date of the mortgage, is sufficient on its own to provide constructive notice of the mortgage.
Of a defective mortgage.
Or that there is a mortgage out there that you're on inquiry notice to determine whether or not what the status of that document is. If someone if you're going to buy a piece of property and you do a title search to the property and you come across the Bank of America mortgage and you come across the 5B affidavit, are you going to say, well, I can buy the property and not have to have the seller pay off that mortgage?
Yeah, but the point is, no, let's just say you can't do that. But then you say, okay, so now I'm going to look at the mortgage. Oh, the mortgage is defective, so I don't have to pay it off.
I think you then look at the mortgage in conjunction with the 5B affidavit
But
and
then
say
you're going back
what.
to saying that the 5B affidavit has to materially correct the mortgage. And I think the question that's being posed is, at least the question that seems to be asked in the second question of the First Circuit is, assuming that's not the case,
If the 5B affidavit
Is not a if the statute is not a curative statute.
If the 5B affidavit is not a curative statute, and if we cannot cure a defective notary by use of a 5B affidavit, then we're back to the question as to whether or not the mortgage is so defective that it doesn't provide constructive notice to a third party. That becomes the other question, which has not been answered, is whether or not the recording of this mortgage, missing the 14 letters of the mortgagor's name, is so defective that it provides absolutely no constructive notice to a bona fide purchaser. That comes back to the question that I believe is an open question. We didn't have to deal with that question in this case because we had a 5B affidavit that we believe, in conjunction with the mortgage, solves any defect within the mortgage.
So how do we answer the second question for the First Circuit?
I think the answer to the second question is that the 5B affidavit, in conjunction with the mortgage, provides constructive notice.
Constructive notice.
I believe it does. And if you look at the purpose of a 5B affidavit, I mean, I believe this is exactly the purpose of what a 5B affidavit was meant to do. You have a document recorded. Now, look, if this document wasn't accepted for recording, we wouldn't be here, because the notary would have, if he went to the registry and the registry said you can't record it, then he would have taken the document back and filled in the name of the mortgagor.
If this were a deed instead of the mortgage, and the grantor's names were not included in the certification or the attestation, and there was a 5B affidavit that provided essentially the same information as the 5B affidavit here, and you were representing the buyer, would you certify title?
I'd be comfortable with a 5B affidavit signed by the attorney as well as a notary. Now, there is a 5B affidavits are just not thrown on record, by anybody. I mean, the statute is very clear. I mean, not only do you have to have someone with personal knowledge, but you also have to have an attorney who's certifying that it's relevant to title to the property. And I think the critical word, is that it's relevant to the title to property. You have a title, you have a piece of property, you do a title search to the property, and you come across the mortgage. The mortgage is an encumbrance on a title. Now you look at it and you say there's missing names of the mortgagor in it. Then you look at the 5B affidavit and you take it together and you say, is that relevant to title to the property? Being, is the mortgage an encumbrance on the property?
If I understand you correctly, I think, well, putting the arguments together, you have to get the answer you're looking for on question 1 to prevail in the federal court, I think.
I believe, I mean, obviously I'd like to get the answer we'd like on both, but in number 1, I think resolves the issue.
Well, it does, but if you don't get the answer that you're looking for in 1, I don't see how you prevail. That's where I'm having trouble.
So, Mr. Johnson, are we a state that requires an inquiry? I noticed that you said that earlier. The suggestion seemed to be here that if the constructive notice, if you have constructive notice of something that's defective, it's not constructive notice. If you have notice of something that's defective, it's not constructive notice. Where does that come from?
The trustee's argument is that if it's defective, it does not give notice.
Okay.
That's not an argument that we're adopting.
I know, but what's the counter to that?
I mean, I think the counter to that is that you're looking at a chain of title to the property, and you're making a determination as to whether or not there's an encumbrance on the property that you have notice of. Now, I'd suggest that when you look at this mortgage, and you're absolutely correct, every page is initialed. When you take a look at this mortgage, you say, this is a good mortgage. Mortgagor signed it, all of the formalities are there, but we're missing the name of the mortgagor in the attestation clause. You then look at the 5B affidavit, which you come across, because that's referenced at the registry as well, and you come across the 5B affidavit, and the notary says that they did appear before me, and they did say it was a free act indeed, and he's correcting that acknowledgement. He's saying that these people were before me. So if there's any question that you had when you look at the attestation clause in the mortgage, you no longer have that question with the 5B affidavit.
What's your best argument for Section 5B being a curative statute?
I think that's the intent of it. I mean, this court has recognized in the Eaton case, when you have a gap in the chain of assignments, that a 5B affidavit can be appropriate in closing that gap. The court has recognized, I think it was the Pinto case, where if there's a question as to whether or not certain notices were given pursuant to a recorded mortgage, that a 5B affidavit could be a way of resolving that as well. And the 5B affidavits are not requiring all parties to sign it. And in this particular case, you have the notary, who is also an attorney, signing it.
What is the extent? I mean, it is unilateral. How far can you go? I mean, let's imagine that the notary did put in both names of the mortgagors, and then does a 5B affidavit later that says, oh, actually, the wife wasn't there, it was only the husband, so it was only the husband who actually signed the mortgage. Can that happen?
I've never seen that happen.
Well, I know, but the question is how far, I mean, your brother speaks of the unilateral nature of this 5B affidavit, which is now potentially altering or affecting the legal consequence of the mortgage. How far do we let a 5B affidavit go?
Well, I think we go back and we just look at the statute. I mean, the statute is pretty clear. You need to have personal knowledge of a fact. You have to have a certification by an attorney that that the affidavit is relevant to title, and that it will be a benefit and assistance in clarifying the chain of title.
Well, the Chief Justice's question assumed that the 5B affidavit would contradict something that's otherwise represented in the documents. Would 5B be intended to allow you to contradict rather than confirm something?
Well, I think the intent of the language is a benefit and assistance of clarifying the chain of title. I think on the hypothetical you've given me, there's nothing looking at the four corners of the document that would need to be clarified.
There's something about the word clarify that's not quite as secure as the word close the chain of title. Does the, and I love saying this, the doctrine of functus officio. Do we need to say that the legislature did not intend that doctrine to apply to Section 5B?
I think 5B has nothing to do with that doctrine. I think 5B stands on its own. I think if 5B wasn't there, then maybe you have some other legal arguments, but I think the legislature passed 5B for a reason. And I think the absolute reason it passed it was so, in theory, we wouldn't be standing here making this argument. There was a Scribner's error. We're not changing material terms of a mortgage. There is no question that the mortgagors signed this mortgage. There's no question that the mortgagors said it was a free act indeed. No one is contesting that at all.
Given the principle of functus officio, and it is a great deal of fun to say that.
I'm going to let you say it.
Good,
Try to say it.
we'll use it whenever we can. If there was no 5B, could the attorney have done the same thing? I mean, what is the legal, why is there a 5B? What's the legal consequence of there being 5B or not being a 5B?
I think 5B is an absolute remedy when you have a case like this.
Okay, but if there was not 5B, could the attorney have done the same thing and just filed something?
I don't know if he could have. I mean, attorneys used to file lis pendens affidavits at the registry whenever they filed suit, and then we had a lis pendens statute that said it had to be filed, had to be endorsed by a court. And that's actually the reason why I'm assuming that the change in 5B was made, which accepts the lis pendens, because there's another statutory procedure for that. But there's no carve-out exception to 5B that would deal with the doctrine that you're talking about. 5B stands on its own. I would look at it as a remedial statute that allows what otherwise would be looked at as Scribner's errors to be corrected. If there was if the terms of the mortgage were trying to be changed to a 5B affidavit, I wouldn't be standing here. But we have the person who notarized the signature putting on a 5B affidavit saying that all the formalities were taken care of at the time of the execution of the mortgage and at the time that he notarized it.
Okay, thank you.
Thank you.